under Fostering Connections. I'm happy to welcome you to this webinar. My name is Madeline Freundlich, and I work with the National Indian Child Welfare Association and the Fostering Connections Resource Center around tribal issues. We are very pleased this afternoon to have NICWA, the National Indian Child Welfare Association, join us in presenting on this very important topic. We want to welcome David Simmons, who is the Director of Government Affairs for NICWA, and also welcome Arlene Templer. Ms. Templer is the Social Services Division Manager for the Confederated Salish and Kootenai tribes of the Flathead. So we welcome them both to this important webinar this afternoon, and we welcome all of you and are very happy that you are here to join us. So going to the next slide. A brief overview of the webinar. I will talk you through just a couple of the webinar features as well as the question and answer tools that are available to you as a participant in the webinar. We'll briefly review the Fostering Connections Resource Center information, and we'll give a history of tribal child welfare as well as the context within which we will be talking about issues today. We'll review the Fostering Connections Law and the tribal provisions of the Act, and we'll be hearing from Ms. Templer with specific examples from the Salish and Kootenai tribes. We will be talking about how states can help tribes in developing their tribal child welfare services, and then we will be wrapping up. So the next slide, please. In terms of the webinar logistics and question and answers, we want you to know that all of the slides that David and Arlene will be using today will be available on the Fostering Connections website after our webinar has concluded. You see on this slide the web address for Fostering Connections, so please keep that in mind that all of this information will be readily available to you after we conclude the webinar. As you see on your screen, there is a control panel feature. You notice the box with the two arrows. That allows you to close the control panel at any time as well as to reopen it throughout the presentation. So in order to read the slide, you may want to minimize that control panel, but then at some point bring it back up. During this presentation, you will be automatically muted, which means that you will not have an opportunity to pose an oral question to our presenters. However, throughout the webinar, you can type in a question for the presenters in the text box that is at the bottom of the question pane where you see a question section, and then hit send. We will be attempting to answer questions throughout the webinar, but it is often possible not to answer all of them, in which case we will be following up with you after the presentation. So once again, you cannot verbally pose questions, but we do encourage you to write your questions, and we will attempt to answer them either now or after the webinar has concluded. Next slide. So about the Fostering Connections Resource Center, many of you are probably already familiar with the Resource Center. For those of you who might just be learning about the center for the first time, its mission is to provide timely and reliable tools and information on all aspects of the Fostering Connections Act. The goal is to make sure that state, tribal, and local decision makers have the information that they need about the new law and that they receive the maximum support that can be provided as they plan for and carry out the implementation of this new act. We are most grateful for the generous contributions of a number of foundations that make the Fostering Connections Resource Center possible, and we do want to acknowledge the Annie E. Casey Foundation, Casey Family Programs, the Dave Thomas Foundation for Adoption, the Duke Endowment, Eckerd Family Foundation, the Jim Casey Youth Opportunities Initiative, the Sierra Health Foundation, the Stewart Foundation, and the Walter S. Johnson Foundation. Next slide. What does the Resource Center provide? Importantly, it provides nonpartisan data and resources on each section of the Fostering Connections Act. By going to the website, you will find a very user-friendly environment where there is a clearinghouse of a range of tools and information that can be helpful to you as you think about the implementation of fostering connections in your communities. There is the most updated list of federal guidances that have been issued, a number of toolkits that have been developed by a range of organizations, research briefs, as well as examples of practices that are being implemented by states and tribes, as well as legislative approaches that states and tribes have taken. Individualized technical assistance is also available. The Resource Center responds directly to questions from leaders at the state and tribal level, and also works to connect decision makers with other experts that may be of assistance to them, as well as providers of technical assistance. The Resource Center each day monitors implementation activity, what is happening at the federal regulatory level, what might be happening in states and tribes, other events in the field, any congressional oversight hearings, and any information that is really coming to light as states and tribes begin to implement fostering connections. The Resource Center also offers opportunities to communicate with experts and peers. We have a range of mailing lists, webinars such as the webinar today, and online discussion forums. And we'll be talking a little bit about those at the end of this presentation today. Next slide. The Resource Center has a number of networks and collaborating partners. The partners really play a central role in the efforts of the Resource Center. As you see listed here, there are 6 national networks of state-based stakeholders who help the Resource Center stay abreast of the questions and concerns that are arising related to implementation of the Act, that help us identify the best practices in the field, and also identify key tools and resources. As you see, and we are so grateful to the National Indian Child Welfare Association, they are our network partners for all tribal issues as they relate to fostering connections, and I am very honored to be the network manager and working with NCWA in conjunction with the Fostering Connections Resource Center. We also have more than 25 national organizations that serve as collaborating partners, and we welcome the opportunity to feature resources by state and tribal organizations, so please feel free to contact us with any tools, resources, best practices that you have developed. Next slide. So today we are starting a discussion with just an acknowledgement of the Fostering Connections to Success and Increasing Adoptions Act, which was signed into law on October 7th, 2008. So we will be looking forward to the second-year anniversary. It's extremely significant federal reforms for children and young people in foster care, and really represents an amazing leap forward in more than a decade from the federal legislative perspective. So with that introduction, I am now going to turn the presentation over to David and Arlene, who will be sharing very important information with us today. Thank you.
David, I just transferred the mouse to you.
Okay. Great. Well, good afternoon and good morning if you're in Alaska or Hawaii. I'm going to give you a little bit of background, just sort of some context history about tribal, sort of some of the what we now know to be sort of the formal tribal child welfare system around the country. Now, this is information that is, some of it's policy related, but some of it is, has to be generalized, and it's going to be different for every tribe. But this is sort of to give you at least a global picture. And I know that Arlene will be giving you some very specific information about sort of how the Salish and Kootenai, Confederated Tribes Salish and Kootenai, have responded to fostering connections and some of the challenges that they have in child welfare too. I want to start with, it's really important, I think, in any discussion about tribal child welfare capacity building to understand that, the formal funding, federal funding of tribal child welfare is really only just a few decades old. Before 1975, most of the services, almost all of the services that tribes tribal children and families received either came from a federal agency such as the Bureau of Indian Affairs, which were often located on reservation, or by state agencies. And even though tribes had inherent sovereignty and jurisdiction, the ability to exercise that was unavailable just because the funds were not there. And even after 1975, as more federal funds became available to tribes, most of the funding tended to be, or at least the base funding, tended to be discretionary. So that meant we wouldn't always know if it was going to be there from one year or another, and many times it was competitive funding as well. And a number of the federal child welfare programs that we often associate most commonly with, such as 4B and 4E, all those Social Security Act programs, many of those were not available to tribes at all until very recently. So what happened? What were the changes that came about to improve tribal capacity? Well, there were some policy changes that certainly made some differences. First was, in 1975, the passage of the Indian Self-Determination Act. This is a law that, for the first time, gave tribes the option of contracting from the Bureau of Indian Affairs many of those services, including child welfare, that had previously been operated by the Bureau of Indian Affairs. So this gave the tribes the opportunity to actually operate the programs in their own communities and do so in a way that met their community's needs more closely. Shortly after that, after about a decade or so of advocacy and a raising awareness about the plight of Indian children and families in public and private child welfare systems, the Indian Child Welfare Act was passed. And most of us who are familiar with ICWA are often focus on or discuss Title I, which is the requirements for states who are adjudicating and working with Indian children and families in their own systems. But Title II provided a grant program, which started in 1979 approximately, that funded tribes for the first time. It was some of the first dedicated funding for tribes. Unfortunately, the funding was competitive up until 1993, and which meant that many times only about half the tribes in the country could even get any of that funding and depend on it, but it was nevertheless some of the first dedicated funding. And then as we move on from 1983 to the present, we see tribes increasingly getting more access to some of these other more commonly known federal programs, Title 4B, 4E, Child Support, TANF. The first kind of access in 83 in the 80s was primarily tribes accessing 4E through agreements with states. So the tribe was actually operating the program even though the state was the lead applicant, but they were doing it as a child placing agency essentially. And then as we move forward from there, we see that tribes also working with states begin to develop more and more agreements. Some of these were funding agreements to access funding, and others were procedural and based many times on some of the requirements and some of the provisions under the Indian Child Welfare Act in terms of coordinating between tribes and states who's going to respond to child protection services cases, who's going to have what role in those cases, who's going to be doing placement activity work, case management, things like that. And sometimes those agreements are both procedural and funding all together. But we know at the current time there are almost 90 tribes or tribal state 4E agreements out there, and probably twice that number of agreements in place that deal particularly with just procedural issues. And one thing I want to mention with regard to the procedural issues is you tend to see those agreements even more so in states where what are often referred to as Public Law 280 states. This is where the state and the tribe share. They have concurrent jurisdiction over child welfare matters. And states like that would include Alaska, California, Oregon, Washington, Idaho, and several others too. And as we also, the last thing in terms of some of the change that advocates helped bring about were changes to federal laws that help tribes and states come together to consult more effectively with each other and help improve service access. Now in most of the major federal child welfare programs, there is some kind of requirement that the state has to consult with the tribe on how certain aspects of the services are going to be designed and operated and how that access is going to occur. And I've listed a few of them here in the, most of them actually here in the slide. So we've got several, we've got about 35 years since tribes, and not all tribes, but since the first tribes probably were able to actually develop with funding, federal funding support, their own child welfare programs. And it hasn't been until the Fostering Connections Act that the largest source of funding, Title IV-E, was available to tribes directly. So there's quite a spread there. So just in terms of a timeline, it gives you some sense of how recent a lot of this capacity building and some of this is probably is. There we go. So Fostering Connections Act, what does it offer tribes? Well, I mentioned direct access to Title IV-E funds, which is very significant. But it also provides incentives for tribes and states to collaborate together. Within the Fostering Connections Act, there are provisions that allow states and tribes to actually increase the amount of federal funding that can be drawn down from 4E based on the ability to use the tribal FMAP, or Federal Medical Assistance Percentage Rate. And there are things, also provisions that require states to negotiate with tribes in good faith. So there are some incentives for tribes and states to collaborate, some new incentives. There's also new technical assistance resources. Many of you may have heard about the new National Resource Center for Tribes that's being developed as part of the Children's Bureau Technical Assistance and Training Network, and they'll be fully operational here, I would expect, probably here soon within the fall. And there are also new resources for tribes being developed by other organizations, by NCWA and by the National Congress of American Indians, Casey Family Programs, a number of groups. So there's a lot of new kinds of resources, exciting new resources that are being developed and becoming available. Also, one of the things that's been very important in any country is to make sure that relatives are involved in those child welfare decisions, and also certainly in placements. Very important there. And the Fostering Connections, not only just by providing tribes the ability to have their own programs, but also in some of the provisions that require the identification and involvement of relatives, I think there's some real enhanced opportunities for relative involvement too as well. And there's also some possibility to shift some existing resources to front-end services and prevention. And what I mean by that is many of the tribes who are doing foster care and haven't been using 4E funds, we're probably using something like BIA funds or maybe some limited tribal funds. With 4E, having that as part of your funding sources gives you the opportunity to be able to maybe shift some of those funds that you were previously using for foster care, adoption, assistance, or guardianship to other areas of the program, hopefully, maybe possibly front-end services, prevention, child abuse, neglect, places where the funding still is in short supply. So there is some transformational qualities to the ability to be able to use the Fostering Connections Act and how you might be able to integrate Title IV-E funds. I think I lost my controls. Next slide, please. So what are some of the tribal provisions? And this part of the presentation, I'm going to actually go over sort of the main provisions that are contained in Fostering Connections. There are several, and most of them speak to some of the specific exceptions that tribes have that may be different than what states have to do in meeting 4E requirements. These are not all of the 4E requirements, obviously, but these are the significant ones that would apply to tribes specifically. So first off, of course, is tribes can apply directly to operate 4E. Now they can do that as an individual tribe, a tribal organization, or a consortium. So there's several different ways that they can do that. They can also continue or develop new 4E agreements, and with that requirement that I mentioned earlier about states negotiating in good faith, I think there's some additional incentives for both states and tribes to come together to develop new agreements. Right now, those 90 agreements we know are situated in about 13 or 14 different states, and we know that there are federally recognized tribes in about 30 states. So there are a number of states where there still isn't, the 4E access is still not as full as it is in other states. We know also that under Fostering Connections that tribes must meet all the 4E requirements provided under the law, except for the Fostering Connections Act provided some specific exceptions, which is much of what I'm going to be talking to you about here in just a minute. The eligibility of the child is determined in the state, that's where the child was removed. That's the AFDC standard. So for most tribes, that will be where their service population is in one state. That will be the state where the child is removed, probably even on the reservation. Because many of you know you have to, in determining eligibility currently under Title IV, you have to look back to June of 1996 and use that AFDC standard, at least in part, to determine eligibility. It's often referred to as the look back. Now, there's also, of course, if you're a tribe that has a reservation or service area that extends into more than one state, such as, for instance, Navajo Nation, Washoe Tribe. These are all tribes that are working to make application to Title IV-E. In those situations, they're going to have to think about how they determine where the child was removed, what state, and also have to look at what the AFDC standard of that state was at the time. Tribes can also define their own service area and population, and service area is geographic, but within that area you have to also define your population. It might only be tribal members, it might be all Indian people, it may be broader than that. And of course that's going to probably require some coordination if it's an area, a service population, an area that goes beyond the typical kind of federally defined reservation boundaries. Tribes can also develop their own federal medical assistance percentage rate rather than having to use the state's rate. Previously, when tribes were in agreements with states, they had to use the state's rate. But we know that the FMAP is based on the community or service area's income, per capita income. And in setting that rate and looking at the per capita income of any particular community, we know in general that most tribal communities have lower per capita incomes, which means their FMAP rate is probably going to be higher than the state, which will bring in more federal dollars for reimbursement. So it's a real advantage both for the tribe as well as the state, especially if the state is helping the tribe with some of the match to be able to use that tribe's FMAP. Okay. As an incentive, as I mentioned, the tribes may want to be thinking about, and the state, how they can take advantage of that opportunity to use the tribe's FMAP. And so, like I said before, many states have provided some of the non-federal match, and that this would likely decrease the state's contribution or for federal, non-federal match payments over time. Another important aspect of Fostering Connections Act is that we know in some cases there may be situations where tribal state agreements may terminate, either because the tribe is going to go to direct funding or because the state is no longer in a position to be able to do the agreements, or the tribe. And we've thought about, I know that many of the people in Congress thought about, well, what happens during those transition periods? And so there's a provision that says that basically any child that's currently receiving those 4E benefits won't have those benefits terminated as long as they're, it's an active case, regardless whether an agreement's in force or not. So these are children who are already 4E eligible being served through the mechanism of a tribal state agreement, but the agreement then terminated. So this is sort of a hold harmless kind of provision to help protect the benefits, 4E benefit levels for children who are currently in the system. Nunc-pro-tunc court orders, that just simply means now for then. This is a situation where we also know that this is many tribes, all tribes, who are going for direct funding. This will be the first time they've operated the 4E program, and for those who were doing foster care before, they didn't have the court determinations requirements that they do under 4E. So many of those tribal court orders for children who are currently in the tribal child welfare system may not completely be in compliance with 4E requirements. And this just allows the tribe, once they've been approved to operate 4E, to be able to go back either through affidavit or through court order to be able to reissue those orders and make them come into compliance with 4E. Now this is a time-limited application, so it's only 12 months from the time the tribe is actually approved to do 4E. But it would help bring in a lot of those kids who may be 4E eligible, income eligible, and otherwise eligible, but the court orders were not in compliance. Tribes can utilize their own foster care standards as long as they are reasonably in accord with sort of nationally developed standards. The National Indian Child Welfare Association several years ago developed some kind of more generic but tribally specific model standards. The Children's Bureau reviewed the standards and said that they met national standards. The Child Welfare League of America also has a set of standards. So this just recognizes the ability of tribes to utilize and develop their own standards. And then another part of this is not a tribal-specific provision, but it relates to relative care providers and the desire to get them more involved, allows two things. One is that the agencies who are doing the licensing can waive non-safety licensing standards for relative care providers on a case-by-case basis. And while we are still looking for guidance on this to know a little bit more about it, specifically what that will look like, I think it does kind of show the direction that Congress was intending, which is to promote relative care providers and help make that their ability to be a resource to those kids a little bit easier while still protecting safety. And the second requirement is that all 4 agencies, this would be tribal or state, have to provide due diligence to identify and provide notice to adult relatives when one of their relative children are placed into care. So making sure that adults, we know that through some of the experiences in the field that oftentimes relatives don't always know when their relative children are in placement and therefore aren't always able to be that resource to them. So this will hopefully address that situation. One of the requirements is that a tribe has to have evidence of no uncorrected, significant, or material exceptions under federal grants or contracts related to social services 3 years prior to a 4E application. And this is just basically making sure that there's the fiscal ability to manage the 4E program, which has a lot of intensive fiscal requirements. The next area, and this will be a couple slides of this, is that tribes have some flexibility in how in the types of sources that they use to meet the non-federal match. Now, of course, when we say match in 4E, it looks a little differently. It's not a true match because you have to expend the funds first and then you're reimbursed for it. So it doesn't look like a match payment like, say, for instance, to a grant program. But tribes' flexibility comes both in the kinds of cash sources that they can use to meet those requirements, as well as they are allowed to use in-kind sources as well to meet some of those in the administration and training area. Now, some of those cash sources can include tribal general fund, if the tribe has that, state general fund, and federal. Not all federal funds, but federal as long as it is 638 or self-governance funds. And that refers to funds that come from the Bureau of Indian Affairs or the Indian Health Services. And there's other statutory law that was passed in 1994 that basically codified this, and so this is an extension and recognition of that. And also private or charitable organizational funds. So let's say a tribe gets some funds, maybe a matching grant from a private foundation or something like that, charitable organization, they can use those as part of their cash match as well. In-kind sources, there's a little bit more information about which of those are available. And first, the in-kind sources that are eligible are tribal. And here you'll notice in parentheses it says other than the tribe applying. That means other than the tribe applying for 4E. This is sort of a glitch in the law. We're hoping that this will get fixed because obviously the in-kind that most tribes would have access to would be from their own tribe, but this is something that we're working with. State or local governments providing in-kind, of course, these funds, if they're coming from a state government, cannot be funded by federal funds like Title IV-B or TANF, things like that. It has to come from state general fund sources of in-kind. And federal programs, this could be, as an example, when it says 638 or self-governance, it could be the funds that support maybe a Bureau of Indian Affairs law enforcement officer who's going to do some training for you, your program for free or something like this. Or again, it's coming from a valid source and one that also promotes the in-kind contributions that meet 4E requirements. Public education institutions, tribal colleges, universities, we often think of these when we in 4E as organizations that are institutions that are involved in training. Private charitable organizations, just like on the cash match, it could be coming in a number of areas, a number of places, whether it's a foundation or it's coming from a corporate giving office. Now there is some other stipulations about the use of in-kind sources. They can constitute up to about half of the non-federal match that's required under 4E administration and training. So if your required non-federal match for either of those two areas, let's say, was $1,000, no more than $500 of that could be coming from in-kind sources. So there is some requirement there. And the Department of Health and Human Services is required to promulgate some regulations by October 1st, 2011 with tribal consultation that will give further guidance and further clarity to whether these in-kind and match requirements will stay as they are, maybe give a little bit more clarity to them, or maybe even change. So Congress gave the HHS some broad authority there to do some more guidance, federal guidance. And tribes, also under Fostering Connections, can receive Chafee Independent Living Funds. And they can do that either by making an application directly to the federal government, as they would with 4E, or they can do it by developing an agreement with a state. And again, the state requirement to negotiate in good faith also applies there. Some of those technical assistance resources that I mentioned, there's $3 million of new funding each year that's going to support the technical assistance that tribes are going to need to be able to operate 4B or 4E. And that's one difference here is that this isn't, the technical assistance is not just centered on 4E, but also on operation of 4B as well. And I mentioned in notation there, I indicate that the National Resource Center for Tribes is part of that $3 million of new technical assistance. So that's a very new technical assistance resource. There's never been one resource center, a national one like this before. There's also one-time development grants for tribes who are seeking to apply directly for 4E, not if they're doing an agreement, but if they're applying directly to run the program. And those grants are up to 2 years maximum and up to $300,000 over that 2 years. The first round, there were 7 tribes that were funded. Confederated Tribes of Salish and Kootenai, or as Arlene, one of the grantees. There's going to be another round each year, and I think the application deadline was extended to August 2nd, so hopefully we'll hear some more about the next round of grantees coming up here in October or so. And the development grantees can use those funds for any purpose to help them build their capacity to operate and submit an approvable plan under 4E. So it's not related to only, it's not limited to only certain things. I think I lost my control again. Next slide, please. There we go. And I think last, I wanted to mention too that there are some, this isn't tribal specific, but that there's $15 million a year authorized for Family Connection Grant Program. Some of you may have heard like the Family Navigator programs, Kinship Navigator programs. This is to help tribes and states and local governments be able to further develop sort of procedures and systems that can promote the involvement of relative caregivers more effectively. And this is in a different section of the bill, and I'm sorry I don't have more information about what the grant announcement for that looks like, but I know that I think it's already been out, and I'm not sure there'll probably be, I would hope there'll be another one maybe next year too if it hasn't, if the timeline's already expired. But this is another example of how the Congress under Fostering Connections was really trying to make sure that the relative care, the subsidies to relative caregivers was emphasized within this. So I'm going to switch over to Arlene, and she's going to tell you a little bit about what the experience of Salish and Kootenai has been.
Thank you, David. Good morning, afternoon to everybody. Again, my name is Arlene Templer, and I'm a member of the Confederate Salish and Kootenai tribes. The Confederate Salish and Kootenai tribes were one of the tribes that were approved in the first round of funding for Direct 4E. We are excited about this opportunity. We have been in a contract agreement with the state for many, many years. Salish Kootenai operates a full complement of social services programs. We have child protection, foster care, permanency, independent living, ICWA, and the Direct 4E grant now. Currently, we have an agreement with the state. We signed an agreement with the state that good for 7 years, but we can opt out at any time we get an approvable plan and start our own 4E grant. We are grant writers in this program, and we do a lot of grants to complement the social services funding that we get. What we have found is that we will never have enough funds to operate on what the feds give us or the states give us or what the tribes have ability to give us. So we're grant writers. We have written grants for fatherhood, and we've gotten a lot of the ARA funds, court assessment projects, suicide prevention. We got a large ANA grant this last year, and we have called it Protecting Our Future Generations. So we are grant writers as well, trying to complement the federal and state and tribal dollars that we have. In Salish and Kootenai, we have a very large service area. We are 1.25 million acres. We border 4 counties. We have a little bit of Missoula County, a little bit of Flathead County, the entire Lake County, and a little bit of Sanders County. We work to intervene in and off the reservation for our cases, the ICWA. As David was saying, the 4E is going to allow us to use the sending states regulations on 4E. In the past and currently, until we get an approved plan, we have not been able to take jurisdiction of our children when they come home, because in the state of Montana, the rules for 4E eligibility is that you had to be removed in the state. So if we bring those kids home and take jurisdiction, we lose the 4E funding and the entitlement for those kids. So one of the things in 4E, the Direct 4E, will fix that, and we're very excited about that. Next slide. It looks like I don't have the ability, so if someone can move the next slide.
Sure, and I'll reset you too, Arlene.
Thank you. Challenges in our current agreement, training reimbursements. We have been requesting training reimbursements for years and have not been able to get the training reimbursements back from the state. We currently just got our first one back in several years. You are allowed to put your training costs in your 4E contracts, and it is a reimbursable line item, but we have had trouble doing that with the state. We feel like we'll be able to do that much easier under the direct funding. The time study methodology. This is quite complicated. We have to monitor our time in 15-minute increments. Here at our tribe, we work 4 10-hour days, and to keep track of what you're doing every 15 minutes is complicated, and it takes a lot of time. The flow of information to the tribe has been hard. We are not on their email, their communication systems with them. So when the state gives out information to their directors or their workers, we're not on that. The only time the tribes would receive policy changes or computer information system changes is if we go to the policy training, and the policy training occurs once a year. Right now, we're waiting for our state services, the guardianships. We have been waiting for 2 years for Montana to step through their waiver system. We have 14 children waiting and have been waiting for 2 years. This causes a lot of problems because parents continue to visit, which is good, and kids continually think that they're going to get to go home, and the parents continue to think that they're going to get their children back, when the permanency goal could have been 2 years ago, guardianship. So it makes it very hard on families. We have no candidates for foster care option or adoption incentive payments for tribes. Our state, Montana, has opted out of candidate for foster care. If the state the tribe lives in opts out, then the tribe does not have the option at all. So we are very excited under the direct 4E funding that we can apply for the candidate for foster care. Other tribes on the line will know that we don't have prevention dollars. We get funding in 4E from the state, which is foster care, already after children are removed, and we get Bureau dollars. And the Bureau dollars, BIA, is mostly to complement those 4E dollars and to keep staff in place, so there's no funding for prevention. So we are very excited about the foster care for candidate for foster care option. Also, we do not get adoption incentive payments. If we do adoptions, the state gets those incentives. They are not passed down to the tribe. However, this year we were able to include it in our 4E agreement. Our 4E agreements were signed within the last month, and we have put that option, negotiated it in. So we are excited to see if that comes to resolution. State workers aren't always trained to work with tribal families. They don't understand the complexity. They don't understand the generational issues and problems that we have had on reservations. State budget concerns, agreements are discretionary. I was able to negotiate this year, even though it's a 7-year contract, I was only able to negotiate a 1-year budget and a 1-year match from the state. So every year we will have to negotiate those dollars and hope that the state will continue to provide the match for the tribe to the 4E dollars. Thank you. Didn't quite go. I'll go ahead and keep talking. There it is. Why we are applying for direct. We want to do candidates for foster care. We see the ability to do prevention. ICWA cases. We will now be able to take jurisdiction of our kids when we bring them home. We can set our own placement rates. If the state's rates are too low and we think that our foster parents and the people providing care need a higher rate, we have the option to do that. Relative guardianship option and adoption incentive options, we can now negotiate those options ourselves. Takeover 4E functions, and the state is currently doing for us. What we plan to do is take over the eligibility function. The reason that we're going to do that is we want a faster turnaround. We also do TANF here. We do TANF at our tribe, and it's within our department. So we will know very quickly if people are eligible for 4E, and we won't have to wait for the state to contact us. We also have the ability to apply for independent living. Currently, we are doing independent living under a state contract. One of the options will be to apply for 4E ourselves. There they come. Create employment for tribal members. By doing that eligibility, we will create, and the candidates for foster care, several positions for tribal members. I'm going to need somebody's help there. They're not coming up.
Okay.
I have several recommendations for tribes. My recommendations are, it's the next slide. Develop your relationships with the state. Make relationships with the 4E specialist. Make a relationship with the governor. Find out who those people are, because when you come to negotiate with them, relationships is a big deal. Sit in or participate on a 4E audit. The state currently invites us to all of their federal audits. So we get to watch them in action, learn what the federal people are looking for, see how they've set up their files, and our files are being audited at the same time there. So we get to actually see and visualize everything that is going to happen in an audit, and it's been very helpful for us. Do your homework. Get ready for those negotiations. Know what other funding is needed to complement the 4E. There's 4B dollars out there. There's a bunch of dollars out there. Be ready for the negotiations and have the right people there. Take an attorney with you. The attorney, they have an attorney on their side. Make sure that you have an attorney. Know that the boilerplate can be changed. Demand your government-to-government negotiations, and don't be treated as a vendor contract. Montana even asked to change the title of the contract to Title 4E Child Welfare Services versus what they wanted it to be called Title 4E Foster Care Services. Train your child welfare staff and your fiscal people and your court people. One of the grants that we were able to get was a court assessment project, and we did some extensive training with staff. We rarely lose here at Flathead a 4E case because of a court hearing or missed dates, because the court has been so well trained, and it's specifically the prosecutor that handles our cases, that we just never miss a step anymore in our 4E cases. It says identify your technical assistance needs and who is best suited to provide TA to your community. Our technical assistance is one of the things that we're looking at now with the direct funding is the computer system or the software system that's going to be able to handle and report back all of the 4E information that's required of us on the ASCARs. We are meeting with people, attending conferences, reviewing software packages so that we are able to do that ourselves. Let's see. Services to consider. I want to bring out some of the services that you should consider when you're going into a 4E negotiation. Look at centralized intake. In Montana, we are going to attempt to stay with centralized intake. Those are the people that get all of the Child Protection Services referrals, and then they come back out to the tribe. We are also going to see if we can stay with their CAP system. That is their computer system, their ICPC. We hope that we will still be involved in all their state trainings, CPS, and 4ETA. We also do our own licensing, and we want to do customary adoptions. So we are very excited about the opportunity to do this direct 4E funding. We had a meeting with the feds yesterday on the phone, and they're complimenting us on how far we are and how advanced we are in our ability to meet their preprint plans and get to where we need to be. We have to have an approvable plan in 2 years. And we're moving on it and going as fast as we can. And I'm very excited today to be on the call. And if anybody has any questions or would like to contact me on how we're doing, our information is going to be at the end of the slides. Thank you very much.
Okay, David, the mouse is back with you.
Okay. Wait a second here while I get it back.
You can go ahead and change the slide.
Yeah. Yeah, I don't think the controls are back with me.
Okay.
But so I'll just cue you. So the last part of our presentation, I wanted to spend a little bit of time just talking about the role of states in helping tribes. There's, anytime you have major child welfare reform like this, it takes a while for people to kind of get their heads around what not only what the provisions are, the new requirements, and even figure out some of the guidance, but it really takes some time to think about what are the opportunities, what are the places that we can really make a difference and implement this the new law in a way that really will help children and families. And one of the things that NCWA that we've always stood by is that we believe that very strongly that anybody who wants to help Indian children and families can be a friend and an advocate of NCWA. And I'm sure I imagine Arlene and many of you out there would probably have the same, operate on the same principle as well. So what we've been trying to do in conversations with our partners, whether they be federal, state, or tribal, is try to identify some of the different opportunities that we think out there. And we know that whenever tribes and states work together and work well together, that the direct beneficiaries of that are Indian children and families. And it's not a mystery at all, and it's something that we continually try to promote. So I've just jotted down a few things that can help. First of all, it's a little bit like I think Arlene says, like doing our homework. We have to become familiar with the tribal provisions and incentives for both tribes and states. The provisions and the incentives may not always, it may take a while to kind of understand them. But as we have those conversations and we ask the questions, I think we all gain from being able to increase our knowledge about what we can do to make use of these new federal provisions. A state can actually save resources. This is something that we've seen even before 4E became available to tribes by assisting tribes either through an agreement or direct funding. And the savings isn't just by the state not having to do the service and maybe the tribe doing it and administrative, but there's actually a savings in funding potentially too. And I'll give you an example. If the state were serving those Indian children on those tribal lands, they would be doing it using the state's FMAP rate, which means that they would have probably a fairly significantly higher non-federal contribution required to meet 4E's requirements. If a tribe is doing it, and maybe the tribe can only do that with some assistance from the state, then the amount of dollars that it takes to do that service, the amount of reimbursement that comes back is going to be significantly different as well, meaning that there's going to be more federal dollars coming into that state for the benefit of those children and families who are in the foster care system, and there'll be the ability to hopefully be able to save some of those non-federal dollars to be able to be used in other ways, to reinvest those basically. And there are definitely savings to be made or had in trying to work together. Next slide, please. So some of the examples I gave, oops, back one, thanks. I talked about the tribal FMAP. And I also think that we know that there was a study in 2005 that was it was put together by the GAO, which is the Government Accountability Office, I believe. And one of the findings in that study is that states, when they're implementing the Indian Child Welfare Act, do depend greatly on tribes to help them do that well, and that they need tribal participation to do it well. And tribes, in response to that, said that they see that need as well, but are limited oftentimes by resources. In other words, they're not able to participate as fully when they don't have the resources. So as we improve tribal capacity, we actually improve state capacity, I believe, to serve these children as well, and that tribal programs become greater resources. And we also know from different experiences in the field and some studies that tribal children, when they're being served by the communities and by the programs that are the best situated to understand their needs, often leave foster care or temporary placement sooner and enter into permanent placements more quickly as well. So all good outcomes, things that we want for all of our kids. And so helping kind of promote that collaboration is another area where we can see some savings as well. Next slide, please. Some other places, for some tribes that choose to have a service area that goes off the reservation, there's going to be a need to coordinate how that's going to look, particularly in the areas of who's going to have jurisdiction and who's going to have service responsibility. And jurisdiction and service responsibility, for those who aren't familiar with those terms, at least in the way I'm using them, when I say jurisdiction, I mean who has the authority to adjudicate a child welfare matter. When I say service responsibility, that means who has the responsibility to actually provide the services. And sometimes it can be the same governmental entity, and in many cases, in Indian country anyway, with the multiple jurisdictions that operate. And it can also be two different groups. The tribe might have jurisdiction, and the service responsibility might lie with the state or county. So there's some important reasons, obviously, to coordinate services, especially off tribal lands. Coordination with tribal children who are being transferred under the Indian Child Welfare Act, and Arlene mentioned this. Those Indian Child Welfare Act cases can be transferred from a state court to a tribal court. And especially if they're coming from outside the state, the coordination issues become even more important. The Interstate Compact on Placement of Children may come into place at some point, possibly. We want to make sure that those kids stay eligible for the services that they've already been made eligible for. And we want to make sure that the case planning is smooth and that there's a smooth transition. So these are all, again, important issues and reasons for states to be having an important role with tribes. And then collaboration and training. I know that there are some states that have opened up their training academies to tribal workers, and this has been very beneficial, and it's helped shape some of the curriculum that they use, and so it's been beneficial to both state and tribal workers. And then the coordination of services and information. Under 4E, we know that child support and those payments need to be coordinated carefully. And also Medicaid. When a child is 4E eligible, they're categorically eligible for Medicaid as well. And there's certainly many of the families who work within the child welfare system also have family also participating in the TANF program as well. So there are all important coordination issues, and with the advent of 4E for tribes, these are only going to take on more importance in the future. Next slide, please. A few other items, making state technical assistance available to tribes and helping coordinate with other sources. It's all about relationships, and in some cases, state agencies may have relationships with other technical assistance providers that tribes don't. I'm thinking also of situations where states may be making applications to receive certain kinds of help, either through a private foundation or maybe a federal source. it always seems to work better when tribes and states are working together, and so this is one of those things that we'd like to also promote. Providing help with tribal non-federal match funding. This is certainly an obvious one. Many of the tribes out there don't have their own sources of general fund, or if they do, it's very, very limited, and much of it is already restricted. So this is an opportunity for a state to be able to help a tribe develop that fiscal capacity to operate the 4E program and take advantage of all of the internal knowledge and skill sets that they do have within the tribal programming. And then also, in some cases, tribes may be wanting to contract with the state to do some of those services. Maybe a tribe wants to have the state, because they've done this much longer, take over some of the eligibility determination work for the tribe, at least in the short term. Or maybe there are other kinds of pieces of 4E work that the tribe may like the state. So being open to that and helping tribes sort of explore those options. And then the same goes with the independent living program. It's not, it isn't just about accessing the funding, but also thinking about how are we going to make sure that tribal youth are getting access to state services. One of the interesting statistics that I learned about 10 years ago is that while Native children in the United States foster care system are overrepresented, they're very much underrepresented in the independent living population. And there's, which is kind of curious, because many of those Indian youth or Indian children who are in the foster care system are also older youth as well. So this is another area where we could do some good collaboration and probably increase the outcomes for Indian youth as well. And then just ensuring that all tribes in the state are full partners when you're doing your planning work for services and developing policy. Starting at the front end, it's much easier to devise and develop good working relationships when everybody has the same information and has an opportunity to be at the table. And not just because it's a requirement, but also because it just makes good sense to try and get the perspectives of others and be able to build into that work those additional pieces of resources that need to be there. Next slide, please. So those were some of the ideas that we had. It looks like we have just a couple more slides, and I think Madeline's going to probably go over these. And I'll let her take care of that. And if we have time for questions, I know some of you have written in some questions. I'll let Madeline see if we can try and respond to some of those.
Thanks, David. I have forwarded some questions to both David and Arlene, and I will just very quickly go through the next few slides and reserve some time to hear from both of them. As this slide indicates, we are very much interested in your questions, both those that you've posed to us today, as well as questions that you may have in the future. Certainly, if you have any questions related to any of the topics that Fostering Connections addresses, please feel free to email your questions to the Fostering Connections Resource Center, and you see the info email listed there on the slide. Also, David and Ashley Horn, who is the Government Affairs Associate at the National Indian Child Welfare Association, can always be reached for questions that you might have about the tribal provisions of Fostering Connections or other issues that relate to tribal child welfare. And you have their contact information also on the slide. The Resource Center also works to provide limited technical assistance or broker relationships with technical assistance providers. So if you have any questions or inquiries in that regard, also feel free to contact the Resource Center. So I believe the next slide. There are many state and national resources available on the Fostering Connections Resource Center website. We've listed just a few here that we felt were particularly relevant to our discussion today. Tribal State Title 4E intergovernmental agreements, connecting children to their Native American roots, and then court reform and American Indian Alaska Native children, increasing protections and improving outcomes. And I know that NCWA has played a particularly powerful role in the crafting of many of these resources. So we've just highlighted a few here, but there's much, much more that we hope that you will visit the website and see what would be available to assist you. And so with the next slide, we're going to be bringing our discussion to a close, but before I think I do this last slide, I'd like to turn the discussion back over to David and to Arlene to maybe answer some of the questions that you have posed to us today.
Okay, I think I'll just try and read the questions, if I can sort of moderate here a little bit. And then Arlene, if you want to respond to it, or I can respond to it, we can give it a shot.
Sounds good.
So the first question that I see here is, how does a state-funded project address the benefits of working with a tribe that independently funds placement and family services? I'll read it one more time. It's a little bit longer question. How does a state-funded project address the benefits of working with a tribe that independently funds placement and family services? Arlene, do you want to take a shot at that?
I was going to take a shot at the next one.
Oh, yeah. All right. I'll try this. I would say that if I'm understanding the question correctly, that you can have a state funding their own child welfare services, and you can have a tribe doing it separately. But if you have if you get the situation where you have sort of silos, and then if we have silos, we typically aren't serving kids as well as we can, because kids have multiple needs, not just health, not just foster care, not just education. So I would say that in the beginning, a state project could do some outreach to the tribe and see what kind of needs that their population has, what kind of needs do their kids and families have, and think about, are there any of those needs that the state might be able to help with. And I think it's as basic as starting that conversation like that. And you never know what the benefits are going to be. And I've spent many years seeing some really amazing creative thinking go on between tribes and states in areas where there hadn't been communication, and then it occurred, and great thing, the light bulbs go on. So I guess I hope that answers the question. If it doesn't, feel free to send it on to us, and we'll try and answer it a little better.
David, I'd like to add to that if I could. Can they hear me now?
Mm-hmm. Yes, we can hear you.
Okay. I was unsure how the question was posed as well, but now I can see which way you went with it. The state, it would be great if they would develop those relationships with tribal people. Once the relationship is developed and a trust begins, then you can start talking about services. But it takes those first relationships and trust building before you get to there. And one of the benefits that the state can have from that is foster homes. I know that there's a lot of tribal kids in the state foster homes, and we might be able to help you in those situations, identify tribal people that are out there to help you with tribal foster homes for your tribal kids as well.
Okay. Did you want to try and do the next one about on or near reservation?
The next one I have, David, that I can see, it says, can you explain why there are no available Title IV funding when a child's ICWA case is transferred out of state to a tribal court in Montana, from out of state to a tribal court in Montana?
Okay.
Montana's rules or procedures for 4E is that you have to be removed in the state of Montana. So if we bring those children in that are on 4E in another state and they haven't been removed here, they lose their funding. It's a residency issue with the state of Montana. Montana has said you must have been removed in the state of Montana. So we can bring them back, but they would lose their 4E benefits if we take jurisdiction and have other funding to support their placement costs. I hope that answered the question.
Is this now? Arlene and I know that they tried to address this in the federal Fostering Connections legislation. Do you think that that was achieved?
I believe it was achieved because now it says that we recognize the sending states' 4E policies. So if they're 4E there, their 4E should transfer.
Okay, thank you. Another question is, says, what are the federally defined guidelines for tribal service areas? On or near the reservation seems vague. Does the federal government have a definition of on or near? That's a great question. And it really, there's an intersection here. And part of it is that Fostering Connections does not define what a tribal service area is. It doesn't have a definition of any type or a reference to it. So in terms of Fostering Connections, it would seem to leave open the idea that a tribe could define their service area fairly liberally, notwithstanding need to stay within the law regarding jurisdictional authority and doing some collaboration with other governments that may be in that same service area. Now, so are there any definitions of what on or near is? Well, under federal Indian law, there are some definitions that try to get to what is on or near, but they tend to be specific to each tribe, and not all tribes have these. So, and not all tribes have reservations, by the way. If you're in Alaska, you don't have a reservation. In Oklahoma, you don't have a reservation. Some of the other areas they have what they call federally defined service areas, in some of the states like Oregon, where I'm from. So, it is pretty. It's kind of vague. It is kind of hard to define specifically for any one tribe. It isn't necessarily a contiguous area within a geographic boundary. So you really have to look at probably what Fostering Connections first authorizes, which is a tribe to broadly define their service area, and then realize that as long as the tribe is kind of working within the bounds of some of the other federal Indian law, they're probably going to be okay. Again, notwithstanding coordination issues, of course. So I hope that's helpful. There isn't any. I guess what I'm really trying to say is there really isn't any specific definition.
David,
for all tribes.
Yeah. David, for the Flathead Indian Reservation, we have defined our service area many, many years ago. In our service area, on or near, we addressed it as within the exterior boundaries of the Flathead Indian Reservation. So all of our programs adhere to that.
Okay. There we go. That's a great example. The next question says, that I have, is how do tribes access 4B monies without 4E program in place? And in order to do that, you have to talk with your regional ACF office. There are 10 of them, 10 regions. And I know there's some ACF folks on the call today. And I believe you can find that on the Children's Bureau website or the ACF website as well. And they would probably, what they would do is be able to help you figure out what the timeline is, when the grant is due, and the application procedures. So it's Title 4B Subpart 1 or Subpart 2. There's actually 2 programs. Subpart 1 is available to any federally recognized tribe or consortium. Subpart 2 is available only to tribes who meet a certain threshold in the statutory language with regard to the allocation they would receive. So I think we're up over a little over 100 tribes right now that are eligible for 4B Subpart 2 funds. So again, ACF will have that information and they would be able to help you. Let's see. Should I take another question, Arlene?
I can't see any more other questions, so yes.
Okay. It says, can a $300,000 development grants be used for tribes to establish a SACWIS system? And I think the answer to that would be yes. You do want to probably be careful about the development of that system. SACWIS system is a much larger, has much more intensive and much broader reporting requirements. So you're not just collecting the foster care or the AFCARs, as they call it, adoption data set, but you're also capturing data for a host of other child welfare services as well, that come about because of other federal requirements and laws. And so while there may be an opportunity to develop a more comprehensive system, which could be very beneficial, with that comes some more obligation for reporting, and the maintenance would probably be a little bit higher in developing that system, and certainly the cost of developing the system on the front end would probably be higher. So, but yes, you can use those funds for those kinds of purposes for a SACWA system.
Can I elaborate on that a bit?
Yes.
This is Arlene. We have looked into the CAHPS and SACWIC systems extensively, and it looks like the states have spent hundreds of millions of dollars to perfect their system, and our $300,000 that we receive wouldn't touch the comprehensive systems that are out there. I am working with the state of Montana to just make some changes to their CAHPS system, and so that we could segregate out enough of the information to complete our AFCARs. And we don't even know if the $300,000 would meet that. They haven't got back to us yet on the cost. We are waiting for them. So we are beginning to look at how do we develop our own system that tracks the information that we need. And then we can make the changes to that so that we're gathering other information our tribal councils and other people are requesting of us.
Great. Thank you for that. That's a great example. And just to be clear, the AFCARs, which stands for Automated Foster Care and Adoption Reporting System, that is a requirement of Title 4E. So all states and tribes have to report into that system. SACWIS includes the AFCARs data, but it also includes much more than that. It's an option. It's not a requirement under 4E. The next question I have is, if a tribe received a 4E development grant, can that tribe reapply later to get another grant? If you've received the development grant, you can't reapply to get another grant at a later date. The language in the statute says a one-time, so it's pretty clear about that. So it's only, you get one shot at it to be able to capture those 4E development funds. And at the end of the 2 years, another important point is that you have to be able to submit an approvable plan, I believe that's the language, to the Children's Bureau ACF 4E plan by that end of 2 years. So it's not, I wouldn't call it strictly a planning grant where you could go in there and say, we're just going to look at whether or not this 4E program makes sense for us. No, you have to already have probably done some of that work and know that you really want to apply for it. So because you have to submit that approvable plan. Let's see. Got a couple thank yous. Thank you. Thank you back. Let's see. That's all I have, unless you have any questions.
We haven't received any other questions coming in over the question line.
Well, okay. I just want to say thank you to everybody for joining us today. I very much appreciate the opportunity to share some of this information with you and some of what Nick was doing too.
Well, I want to thank both David and Arlene for such an informative presentation, bringing us information that is new for many of us. It's extremely enlightening, and I want to thank both of you so much. For everyone participating in this webinar, there will be copies of the PowerPoint slides from which David and Arlene were working that will be posted on the Fostering Connections website. There will also be an audio recording of their presentation, so that is available as well. The next webinar, hosted by the Fostering Connections Resource Center, will be held in September and will focus on the health issues that are addressed in Fostering Connections. More details will be forthcoming. You will get notices of that webinar, and we just encourage you to sign up to be notified of them if you haven't already signed up at the Fostering Connections website. There is a new LinkedIn group discussion forum, Fostering Connections Implementation Work Group. You can find a user's guide to link in and also register for that group, once again, at the website, and that specific web address is listed here for you in the slide. The Fostering Connections discussion group offers subgroups on very specific issues related to the implementation of Fostering Connections, including tribal issues. So please check that out and see if you would like to participate in one of those subgroups. Once again, we would be delighted to hear from you. You have here on this slide the email address for the Fostering Connections Web Resource Center. You have how to contact both David and Ashley at the National Indian Child Welfare Association, as well as how to contact Arlene Templer with the Confederate Salish and Kootenai tribes, the Flathead, as well as my email address. So I want to thank everyone for joining us for this very informative webinar this afternoon. Again, thank David and Arlene. And let's end by looking at this very final slide from the National Indian Child Welfare Association. Beautiful quote from Sitting Bull. Let us put our minds together and see what kind of life we can build for our children. Thank you very much for your participation.
Thank you.
Are we off too?
Oh, Arlene, is that you?
Yeah, I didn't know if we were off as well.
If you close out the, we might